For prosecutorial discretion and what we can do in the court, especially for individuals that have criminal charges and they're detained and they have a hold of immigration, for us to be able to negotiate the lift of the hold, we have to have something that makes it, I don't know, humanitarian, let's put it that way. And to prove to the court or DHS that this individual is really not in their priority. So if we can show them that this person has been in the United States for an extended period of time, that they have ties to the country, compelling humanitarian factors, and his health is not really going to count much, but family members and so forth will help us to order that. Now, who's eligible for a bond in immigration? Those who are not arriving aliens, as I stated earlier, and those who are not subject to mandatory detention. There are some that there's nothing that we can do. The court will be looking into flight risk. Somebody that has not been in the United States for quite a while is a flight risk. Somebody that doesn't have some form of relief before the immigration court is a flight risk. Somebody that has a pending criminal court, according to the immigration laws and a precedent from the Board of Immigration Appeals, is a flight risk. But they will also consider they're a danger to the community, and what relief is there? If there's something that we can do in immigration court. When we do the bond hearing, the judge will consider how many relatives he has in the United States. If somebody comes and says, I'll feed him, I'll keep him at home, and I'll guarantee that he goes to court, that always helps. If they have children in the United States, if they have obligations, they have to pay for a loan for a car or for a house or an apartment. Something that helps us or helps the judge understand that more likely than not, this guy actually will show up to court. But some individuals are not eligible for bond, and we cannot get them out. And some of those are the ones that are convicted of aggravated felonies, as I said before. ICE is required to place into detention and mandatory detention anybody that was released after October 8 of 1998 and has one of the offenses listed on this list, which are crimes involving moral turpitude, where the sentence was 1 year or more, unless there's falls under the petty offense exception. 2 or more crimes involving moral turpitude, controlled substances, money laundering, prostitution, firearms offenses, and aggravated felonies, among others. So the individuals that are already here in the United States, like legal permanent residents or individuals on work visas, can also be mandatorily detained if they have 2 crimes that involve moral turpitude, aggravated felony, controlled substances, or firearms as well. Now, a person that is seeking admission, let's say a legal permanent resident, goes out of the country and is coming back into the country, he can be mandatorily detained if he actually has only 1 crime involving moral turpitude. The petty offense exception applies only if the offense occurred after 5 years of admission as a legal permanent resident. If not, they're inadmissible. Drug trafficking offenses, 2 or more offenses with the aggregate sentence of 5 years, prostitution, and domestic violence as well. As I said, the statute of mandatory detention was enacted and on October 8 of 1998, so it applies from cases from there on. We recently had a case with a judge of a guy that had a murder before 1998. And the forms of relief for him are very limited. And we applied for the bond, and the judge was laughing, like, this guy is subject to mandatory detention. And nope, he wasn't. And we actually got a very high bond, but we got him out. Now we're trying to figure out if someone can help us with post-conviction relief, because we believe the person needed to be killed. But who doesn't need to be detained? Well, any type of minor convictions, like small thefts, Class B thefts, will not really trigger any of the statutes that we've discussed. Believe it or not, individuals are not mandatorily detained for driving while intoxicated. Now, if they have 2 or they have 3, immigration judges have discretion, and if they really think that the safety of everybody else is at stake, they will deny bonds. Now, for example, if an individual has, and these are cash bonds, they have 2 DWIs, we're getting bonds for $15,000 or $20,000. Yes? It involves moral turpitude. I'm sorry, but did I say that it didn't? My mistake. It should have read like Class B's that the sentence is less than 6 months. It would fall under the petty offense exception. That's a mistake. I apologize. So let's talk about some myths and that everybody hears and we are asked in court all the time. A non-citizen that is married to a U.S. citizen is not deportable. I've seen criminal attorneys go to an immigration court and tell the judge, you cannot deport my client. My client is married to a U.S. citizen. You cannot deport him. And the judges will tell them, watch me. There is no such a thing. Marrying a U.S. citizen is no guarantee that you're going to be able to remain in the United States. Having an anchor baby is not a reason why you can remain in the United States. The process of helping somebody to sponsor somebody to become a resident of the United States is very complicated, and it really depends on if the person entered legally to the country, if the person is eligible to be able to obtain a visa here or outside of the country. I can marry a citizen, but if I have a prior deportation order, I cannot become a legal permanent resident in the U.S. I have to go outside of the country and process outside. A U.S. citizen can petition and sponsor for residency his spouse if they entered legally to the country. They have to have that legal entry, and at that point he can petition for them, and it's a lengthy process that involves interviews and so forth when they will determine if this individual actually merits to become a legal permanent resident. But that doesn't mean you cannot be deported for criminal convictions, and if you have a baby in the United States, well, when they turn 21, they can petition for you. But if you enter illegally to the country, you have to leave the country and do it at your consulate. The law says that if you have been in the country illegally for over 1 year, when you leave, you get a punishment that you cannot come back for 10 years. So it is really a myth. Another one, a lawful permanent resident cannot be deported regardless of his offense. Well, legal permanent residents are really guests that are allowed to remain and live in the United States while they actually observe the laws of the United States and conform to the American ways. So as we discussed before, any type of aggravated felony will render them deportable without any form of relief. And there's nothing we can do. In very limited circumstances, there's some case law from the Board of Immigration Appeals that would allow us to readjust them and remake them a legal permanent resident with a pardon. But when there's an aggravated felony involved, we would have to show outstanding equities on his case and that he's really, I don't know, an asset to the community. And that is a really high standard. There's one of the regulations that actually says that the Attorney General will not exercise a favorable discretion on cases that involve aggravated felonies or crimes of violence. So it is really, really hard to obtain. Another myth. Oh, the parents of anchor babies, I discussed that one already. Yes, they can be deported. And it's really funny that they will deport them with their baby U.S. citizens. And immigration courts, the Board of Immigration Appeals actually believes that children do not get affected if they're deported to Honduras, the capital of murders of the world, because they're children and they don't know where they're at and they can adapt quickly. It's incredible, and I'm hoping the laws will change in the future with that regards. Some things to keep in mind. You have to be careful when recommending and agreeing to a plea bargain. Again, consult with an immigration attorney. It may seem that it's okay. It will look what you remembered, but always consult with an immigration counsel before making a plea. And on the negotiation of the pleas, once again, on the assaults, if we can avoid the family violence finding, which is really hard, and I understand that. But any time that you can negotiate 12 months instead of a year will never meet the definition for aggravated felonies on those offenses that actually can become aggravated felonies because of the sentence. Always remember that a deferred adjudication will remain a conviction for immigration purposes because of the definition under the INA. And controlled substance offenses, sometimes if you can get a conviction for possession of drug paraphernalia, some courts have said that it is still a drug conviction Recently, the Supreme Court issued a case where they said actually, well, but the paraphernalia has to be related to a drug. And if it's not, then it's not a controlled substance offense. And because the controlled substance offense usually is not mentioned on the indictment or on the judgment, they cannot prove their case. You have to really be extra careful with the cases of domestic violence again. If it can be negotiated, if this guy could be sent, I'm not sure, to boot camp or to wife camp or something. Something that would really be an alternative, diversion programs, anything would really help us. And the petty offense only saves non-citizens seeking admission. When you're applying to come into the country, if you have a petty offense, they cannot stop you. If you're applying to become a resident, you don't have to apply for a pardon. But a legal permanent resident can be deportable for the tiniest petty offense exception. If the offense involves moral turpitude and it happens within the first 5 years of their admission into the country, they can still be deportable. That doesn't mean that they're going to be deported. There are some that actually can be readjusted, as I mentioned before, can become legal permanent residents again. But the reliefs that we have in court for them are very, very limited. And finally, when in doubt, you can always read the Immigration and Nationality Act. Some of my criminal attorney friends have compared it to the tax code. It is really complicated. Every day there's another decision from a circuit that changes everything. Up to 2001, they were deporting everybody that had 3 DWI convictions because they said it was an aggravated felony. Came the Fifth Circuit and said it's not. But they had deported thousands of people already. Once you're out of the country, we could not do anything. A couple of months later comes the Fifth Circuit with 2 other decisions that says, yes, even if you're deported, you can reopen your cases. So we start bringing them back. And then they noticed that we were bringing them back. And they found a way of trying to stall us and saying, well, that's not a regulatory part of the law. It's really, it's in the regulations, I'm sorry, not on the law. And now they're placing obstacles here and there. We still can bring them every once in a while if the government attorney does not respond to a motion to reopen, but it can be done. Yes, sir. They can still do it, but you would have the arguments and the case law to support you. Assault cases, for example, until, I don't know, a few years back, the controlling case was called Matter of Fulao. It was a Board of Immigration Appeals case. And it stated even that if there was an injury, it was still simple assault and it didn't really involve moral turpitude. And it was because of that California case that suddenly they're saying, oh, this is to protect family members and that has to be bad, so we're going to make the same findings. But it's being fought right now. And we actually expect a decision by there's like 7 or 8 cases before the Fifth Circuit, and a lot of agencies are involved in the litigation right now. We expect something this year, if not early next year. I don't understand the question. Yep. We've never had a judge find on a simple assault that there's no finding of domestic violence that is a crime that involves moral turpitude. Let's put it that way. I know of other attorneys that have not been successful, but we have always been. Yes. That would be, no, aggravated assault would be a problem, felony would be a problem, because the aggravated assault statute in Texas requires a more serious injury. The good thing about the simple assault statute is that it only says bodily injury. So a pinch could be bodily injury, you see? So that's why we argue you cannot look into the indictment. So how will you know if what was if it was a sizable type of bodily injury. We don't know how it was. So we do have strong arguments in that type of case. There's no B, but if it's simple, yes. Any other questions? Yes, sir. No, DWI will never be considered a crime involving moral turpitude. You don't have any intent to do anything. You're drunk. So there will not be anything. So those are good, but if you have too many of those, can be a problem. Some judges are refusing to give bonds now to individuals with 2. So if there's no video, well, we've had some that if it's a recent one, they're saying that they're a flight risk, a risk to the community because they don't have a license and they needed to take a course. And it's like, well, they've had a license in Mexico for 50 years. But they're saying no, and they're denying bonds in some of those cases right now. Any other questions? Yes. Yes. Okay. No, any legal permanent resident is deportable for a controlled substance offense, excepting possession of 30 grams of marijuana or less. That's why I made the joke that legal permanent residents can smoke pot. But any other drug, Xanax, any other drug, cocaine, will make them deportable. And possession of a drug, there is relief for legal permanent residents in a possession case. So if they have possession with intent to distribute or possession with intent to sell, they're gone. But if we get them to a simple possession,